Okay, year 13. Here's your support video with this particular question, 25-mark question, which is comparative. Citizens' rights are better protected by the judiciary of the US than in the UK. So, if we're considering this, the question is, where do you start with your planning? Well, three key questions to answer. What are citizens' rights? What's the key terminology I want to make sure I'm trying to use in this answer? And what am I actually going to compare? If we're talking about what are citizens' rights, it's important to stress, certainly in introduction, the fundamental nature of them in regards to liberal democracies. The effective protection of rights has actually become more relevant in recent times with concerns over national security and COVID restrictions. So therefore, there's a context in which you can have this discussion. So what's the terminology I want to use? Well, from the United States side of, you want to be emphasizing judicial review. You want to try, if you can, to talk about strict and loose, about restraint and activism, and you certainly want to talk about the amendments in the Bill of Rights and the way in which the court has had, with certain examples, enhanced rights over time. From the UK sort of, again, you're talking about judicial review, using terms like ultra vires, incompatibility, and some examples perhaps of how rights have been enhanced in more recent times as well, and how the court has become more active over that period. So this is like a standard knowledge that you would want to try and incorporate at some point throughout this particular essay. So, three areas I wish to compare. So when I'm planning out my essay in terms of the three key paragraph points, I would say you want to be comparing on constitutional powers, which of these courts are more constitutionally powerful in protecting rights. Two, which of the courts is probably more active in the protecting of rights on a day-to-day basis. And thirdly, you could perhaps look at the limitations and see whether there's similarities there in terms of how they do or they don't protect rights. In terms of the debate, as I've said, traditionally the US has been seen as more influential and prominent in regards to how it protects rights under the US Constitution. However, more recently you could say there's been challenges to this. The more conservative court we see now perhaps could be argued to be less active, I guess, in protecting rights. You could talk about the fact that executive power has grown in both the United States and the UK as a threat to civil liberties. And then perhaps you could talk about as well the nature of the UK court, the fact that it's risen more to prominence than perhaps it was in the past. It's become more prominent part of our political culture. So let's get into the paragraphs themselves. The first comparative point, which is looking at the constitutional powers of the court. Now, I think for this, you want to really stress the contrast that exists. On the US side, you have judicial review based around Marbury versus Madison. The fact that the court has the means to strike down state law, federal law, and executive actions as unconstitutional. It has that role as the key guardian of the constitutional rights, and therefore it's hugely prominent. And then what you would want to do is give some examples of this. All right, as I've suggested here, the flag burning example in Texas, Trump's attempts to restrict travel through executive orders. The entrenched nature of the rights in the United States in the Bill of Rights certainly puts the Supreme Court in a key position constitutionally. And this clearly contrasts the UK, where their main power is obviously to declare government actions as being incompatible. And fundamentally, you need to talk about parliamentary sovereignty in this paragraph. You need to show that the sovereignty within the UK sits with Parliament, whereas it sits with the Constitution in the US. And as a result of which, it's down to Parliament whether or not they enhance or restrict rights. Anti-terrorism law restricting rights, or the more recent police bill, or against the opportunity to enhance rights such as freedom of information, that sort of thing. So in an evaluation, the point you would want to be making is the definitive nature of power that exists between the two courts. And the fact that the US Supreme Court is much more definitive in the nature of the power that it holds rather than that of the UK. Okay, the second one is really going beyond the nature of power to talk about how is that power used, how active are the courts in protecting rights. And in both cases, you can talk about the activity of the court growing over a period of time. For example, in the United States, you would want to talk about how there has been an element of judicial activism, the fact that some courts have sought to see themselves as key to developing public policy to the point where they've been accused of being legislators from the bench. Examples, obviously Roe versus Wade, the more recent example of same-sex marriage. And that shows you that the Supreme Court has the capacity certainly to enhance rights beyond those that were set in the Bill of Rights in 1789. And then in a similar way, you can talk about the way the Supreme Court, having been created, has grown in its prominence, and as a result of which the cases that have come to him have grown as well. So lots of different ways in which you can give illustration of how the Supreme Court now is much more put forward by the media as a means by which the grievances can be resolved. And this has been shown, for example, in the case of Johnson's wish to prorogue Parliament, and the Supreme Court saying that was beyond parliamentary sovereignty. So, in evaluation, both courts can be seen as increasingly at the forefront of decisions around citizens in modern times. Okay, this would suggest that the growth of the Supreme Court in the UK is almost to the stage where it's having equivalence to the US. But you would have to say that it's still the issue of parliamentary sovereignty, which means that power really sits with Parliament rather than the US. The third point is really to look at limitations. And I think the important point here is to show there are similarities between the limitations of both courts. Both are reliant on cases being brought to them. Therefore, there's the capacity for them to actually engage with rights really depends on whether or not those cases can be brought, and as best shown probably by the NECP in the 1950s with segregation in schools. The Supreme Court can't actively look for these things unless the cases are brought to them. Then you can talk about the composition of the court. The concern that the UK court is essentially a reflection of the establishment elite, and therefore perhaps has a potential bias against certain groups in society. You could talk about the nature of the conservative court that's more recently existed in the United States, and the fact that it may look to perhaps diminish rights compared to liberal courts of the past. So the nature of the court and the focus of the court could be a factor in how well it protects rights. And finally, both rely heavily on the authority and legitimacy of their constitutional position. They cannot enforce their decisions, and therefore in themselves they can't actually directly protect rights. What they can do is they can steer the enforcement of rights in the country. Therefore, although both courts can protect rights based on the law, that's de jure, in the reality of the rights are protected in individual societies may be limited, and that's de facto. And therefore, if you wanted to, you can go further with this. And certainly, you're reading as you go in to read about civil rights in the United States with affirmative action, voting rights, and so on. You can give good examples of how de facto rights may be still limited in the United States. So, if it was a conclusion for me, it would be that fundamentally citizens' rights are better protected in the United States. I would still acknowledge the fact that the UK Supreme Court has become more prominent, and still that both courts have clear limitations in what they can actually achieve. But the reality is the US court still probably holds greater capacity to protect rights. And this is based purely on the constitutional position. I think this is the thing that really defines the argument. Parliament holds sovereignty in the UK, therefore they are crucial to rights, where the Constitution is sovereign in the United States. And the UK's capacity to rule acts and actions as unconstitutional mean really do have a much more effective way of protecting rights in their country. Okay, I hope that's helpful. Good luck with typing that up, and it should be a decent answer. Thank you.